So, like Gary, I've also lived in Castle Ward since 2015. We've struggled with issues of antisocial behaviour, which the police are aware of, as well as issues with noise, burglaries and such things. While we welcome the fact that there are shops in the area that serve the community and the greater city of Derby, we also want them to be not contributing to those issues. When the shops are open that late, it just encourages, and it's going to set a precedent for more shops to be open quite late. Most of the residents are families or professionals that are working, and so that's something we need to take on board. And I think also the representation of the 30 signatures is what we could get together at the moment, but there are more residents that have come forward since then to show the fact that they would support as well the shop not being opened until that late.
Yeah, we just add to that point as well. It is a mix of professionals and families. We cannot easily amend our sleep patterns to adjust for these late hours. We've got an infant 2 doors down. They're also concerned that their dog barks if they hear loud noises at night. And yeah, again, it's just not simple for us to adjust, given the premises that everyone's moved into the area. One further point actually. They also haven't clarified who will be doing the deliveries. Are they doing the deliveries themselves, or is it going to be Deliveroo or some other app? And if it's like Uber Eats or some other company, then they don't have any control over the actions of those people. They can't take any credit for that.
Thank you, Chair. Yeah, I noticed that this unit in question is one of a row of shops along the promenade there. Are you aware of the closing times of the other shops along there? Are there any others that stay open into the evening, for example?
Yeah, I've documented those in the representation form. So there's, in that row of shops, there's no late evening ones. There is a yoga shop adjacent. The yoga studio is open till 9:30, but everywhere else closes generally at about 6 o'clock. I think there might be one other one at 9, but they don't have any impact at all when the residents are in unison with the goal of the area. And there never has been any shop in the area in the last 10 years that's opened past 10 o'clock.
Okay. And can I just ask about arrangements for deliveries and so on? Is there shared access with yourselves and the other residents who live above, or are there separate arrangements for taking in deliveries and so on for those shops?
We have separate entrances to our properties, but the doors are effectively next to each other. And as I say, where we sleep is directly above where the entrance to the shop would be, where the delivery would be undertaken.
So, Mr. Semper, would you like to present your case now?
Thank you. There I am Nick Semper from the Licensing Guys, and I'm representing the applicants here today, being MS Delights Limited here in the persons of Shuab and Adam Mohammed. By way of introduction, these gentlemen will be opening these premises as a desserts cafe. They have no intention to serve any alcohol whatsoever, selling only desserts, i.e. milkshakes, gateaux, cakes, ice creams, and cookie dough, waffles, teas and coffees. That's it. So why do we need a premises license at all? Because tea, coffee, waffles and cookie dough are hot or warmed food and drink, and a supply of hot food and drink after 2300 hours, between 2300 hours and 0500 hours in the morning, is a licensable activity and therefore requires a premises license. So, should this business fail to be granted a premises license today, then they can still continue to trade the hours that they want, but just not doing hot drinks, waffles and cookie dough after 11 o'clock at night. The next thing to realise is this application is submitted by Schwab. Schwab knows all about the desserts business, but as members of the Licensing Committee, you will know that the Licensing Act 2003, the attendant regulations and Section 182 guidance, and your statement of licensing policy are not for the faint-hearted. He made a fateful mistake and he indicated in the application that he would be open to the public until 2 o'clock on the application, and that the premises, and that he actually didn't mean that. He assumed that he would be serving desserts to the public at night, but actually, and that's why he put those hours on, but actually the public will not have access to the premises after 2300 hours anyway, whereupon the cafe element of the business will close and the delivery-only operation will commence, will continue. Okay. Lastly, in our examination of any planning consents and permitted uses for this development, it is a mixed-use development, and there are no restrictions. The only restrictions on the hours are contained within the lease. I've got a copy of it here. And the opening hours are found on page 4. It's 7:30 in the morning until 11 o'clock at night. And then if you turn to page 20, if you turn to para 22.2, which is on page 15, it says that they can operate a delivery-only service on Mondays to Thursdays, 11 p.m. until 0100 hours, and Fridays and Saturdays, 11 p.m. until 0200 hours. That's why the hours have been adjusted to be in complete accordance with the lease that they have on this premises, which was written by the lawyers to be compliant with the planning permissions they have on that building. There will be no alcohol. Therefore, there is no requirement for a designated premises supervisor, and any control measures regarding age-restricted products or restrictions to the under 18s are not required because they will not be on the premises after 11 o'clock at night. So thus, this is now what your lawyer would refer to as a de minimis operation in licensing terms, and puts, in my respect, most of the issues raised by the representatives effectively to bed. And the conditions proposed in the operating schedule are intended to ensure the robust promotion of the licensing objectives and a safe, legal and compliant operation in every respect. Now, as you'll be aware, each application must be judged on its own facts and merits. The significant merits of this application, it is a quality application, correctly conditioned now with specific, appropriate and proportionate control measures, thus minimising any potential that any licensing objective would be undermined. Now, in this hearing, the burden is on the applicant to show that the proposed operation, i.e. me and the guys here, supported by the proposed operating schedule, is capable of promoting the licensing objectives and is unlikely to undermine them. Any representatives, Mr. Gillespie and his supporters, opposing the application, have the burden to show that these premises, trading under the operating schedule before you in the terms now before you as amended, will undermine the licensing objectives and demonstrate that with evidence. In our submission, any subcommittee properly advised could only refuse this application if it is found on the evidence of Mr. Gillespie and his supporters to be not capable of promoting the licensing objectives. So you may ask yourself, why does Mr. Gillespie and the representatives, aka objectors, need to produce evidence? And the answer is found in para 9.43 of section 182 guidance, where it clearly states, and I quote if you'll allow me, the authority's determination, i.e. your decision here today, should be evidence-based, justified as being appropriate for promotion of licensing objectives and proportionate as to what it is intended to achieve. Significantly, there is not a shred of evidence in the comprehensive hearing bundle put together by our friend here from the licensing authority which challenges, criticises or even references the operating schedule, the applicant or any other business operated by these applicants whatsoever. There is absolutely no history of disorder, noise complaints, child protection or safeguarding, or indeed any other cause for concern evidenced involving these premises or these applicants or any other premises related to them before you. That is an undeniable and self-evident fact. So first, if you allow me, I'll walk you through who has, or rather in this case, who hasn't raised an objection. Firstly, the police. They are the lead responsible authority and source of expert evidence on all crime, disorder and ASB issues in Derbyshire under para 2.1 of the section 182 guidance. And they've made suggestions which we've been pleased to accept. Conditions 1 and 2 will need amending slightly, but whatever. Please note that in our opinion, that revised application no longer requires the impositions of conditions 1 and 7, as they're no longer relevant, and should not necessarily be included in the grant of any licence should you see fit to grant one today. But the overriding message from the police, from me regarding the police is, there is no extant representation or objection from them before you. The licensing authority, being the lead responsible authority in all licensing matters in Derby City, they've made no representation. Trading standards, children's services, the responsible authorities who protect children from harm, public health who deal with harm to health and substance misuse, the planning department, themselves a statutory consultee in this process, they've got no issues with it, and neither have environmental health, being the experts in noise and pollution control, and therefore the lead agency on the public nuisance licensing objective in Derby City. These bodies all raise no objections. Now, this hearing is an evidence-based decision-making process. You, as a committee, cannot be insensible to the fact that not one of the lead and expert responsible authorities has objected to this application or has presented any evidence against it. You can therefore rightly assume that, in the opinion of all the responsible authorities, the operating schedule does not undermine, but in fact promotes the licensing objectives. Otherwise, they would be here with evidence to argue vehemently against it, as is their statutory duty. So we are then left with the objections from the members of the public, and I don't think we're deaf to them. That's the first thing to say. No doubt, there is no doubt in my mind that these come from good people, but we need to think carefully about what they're complaining about, and particularly how relevant they are to the current application before you. So instead of dealing with each person, I'll break down the arguments raised by heading and deal with each in turn. But the overview looks very much like this panel. The petitioners complain about crime, disorder and public nuisance. They don't want the premises open until 2 a.m. at night. As I've explained, now it won't be. They're not happy with its use. Now, as I've told you, there are no planning restrictions on permitted uses, and the lease stipulates that it may be used until 1 o'clock and 2 o'clock respectively, depending on the day of the week. In any event, paragraph 14.65 of this guidance, of the section 182 guidance, clearly tells us that planning permission, business control approval, and your licensing regime will be properly separated. Therefore, business use, which the majority of these concerns are around, is an irrelevant consideration for the licensing committee, and any issue should be referred to the planning authority. That would be my respectful submission on that. I just remind you that there is no cumulative impact assessment or special policy area covering this place, and therefore any light restrictions simply don't apply here. So dealing with the crime and ASB, because Fatima mentioned it, ASB, noise and burglaries in fact, the police have no issue with this application and the inbuilt safeguards entailed. The statutory guidance clearly tells us under that para 2.1 that they are your source of expert guidance, and it's not for others to stand in their shoes. Personally, I do not understand the link between a burglar in the area and the selling of milkshake and desserts, but okay. If there are any pre-existing issues with alcohol-related crime and ASB in the area, then it cannot be the fault of the applicants before you, as they're not open and they've sold no alcohol to anyone anyway. They've certainly not burgled anyone. Okay, but lastly is the issue of noise. As these premises would not be open to the public, the noise cannot come from the customers. This leaves the delivery vehicles picking up desserts for delivery to the neighbourhood. And you've asked how we're going to do that. We're going to do that via Deliveroo, wasn't it? Was it Uber Eats as well? Uber Eats as well. This plan primarily, their plan is to primarily use bicycle-borne couriers. Okay. Now, we've also provided, and it's in your bundle here, a comprehensive noise management policy, which is before you. Any vehicle drivers that do attend will be briefed around noise reduction and disciplined if they breach that policy. Mr. Gillespie says there is no control over third-party couriers. That's simply not true. There is a contract, and the contract is a two-way contract. There are terms within it about our expectations and the delivery of third-party couriers' expectations around behaviours, timeliness, cleanliness, noise, disorder, not noise, nuisance, stuff like that. Okay. Okay, so the ultimate goal, I'll tell you what, that's in the future. I'm going to talk to you very, very briefly just on fear and speculation, if I might, and I will always defer to Mr. McCabe, who is your lawyer on this matter. I'm not a lawyer. I'm trained in law, but I'm not a lawyer. But it seems to me, and you take advice on this in recess, please, it seems to me that the public representatives speculate that were you to grant this licence, then they fear that there may be problems upstream. There are two main reasons why fear and speculation are not admissible in these proceedings in my submission. Firstly, para 9.43, as I've already explained, says your decision must be actually evidence-based. Okay? Fear and speculation of what might or might not happen at some undisclosed point in the future with a noisy delivery van driver who will not abide by the policy that we've provided, that is actually fear and speculation. It is not evidence. Okay? And secondly, there's a ruling in Daniel Thwaites and Wirral Magistrates, which case went to the Court of Appeal, Queen's Bench Division 2008. Daniel Thwaites and Wirral Magistrates. Okay? And the judge in that was Her Honour Justice Black. And in the judgment she handed down, she indicated that your decision-making here today should be actuated by proper and real evidence. There is no history of problems with this applicant or these premises, nothing before you from the responsible authorities, and the potential for any such issues is more than properly addressed in the proposed conditions and the noise management plan. And in any event, I would reassure everyone here, because it's law, I mean, I'm not making this up, Parliament has already provided a mechanism whereby you as a panel, you as an authority, can deal with future problems emanating from this or indeed any licensed premises conducting licensable activities in the City of Derby, and that is the Section 51 review procedure under the 2003 Act. So were you to grant this licence here, this de minimis licence here for the delivery of cookie dough and hot drinks after 11 o'clock at night, and there were problems, and we're saying there won't be, but I can look into the future as easily as anybody else in the room, but there were problems, then you have the power to control them through the aforementioned Section 51 review procedure, okay, as I'm sure you are not scared to do, okay. So look, that's where we are. We're going to do some summary in a minute, but if you've got any questions for these guys, I'm sure they'd be pleased to answer them. Thank you.
Right, thank you for that. Thank you for the noise dispersal policy that you've just described in front of us. I'm going to refer to 2.2. Has the premises licence holder already got in place designated duty managers to cover all of these hours of operation? That's a really good question. There are 4 staff at present, or they're anticipated to be 4 staff. 2 will be managers, and you're looking at 1 here. He will be managing the day-to-day. So primarily, it will be his job to make this, which is just a piece of paper with some black writing on it, to be honest with you, to make this an operational requirement. And I might invite you, actually, to add a condition that there will be a noise management plan that will be available to the, within the licence, which will be available to the responsible officers, and to which they can be held to account if they fail to live up to it. So. And if I refer to 3.6, there's more than 1 duty manager which is actually designated. Does this information already exist? Is it already produced, and has it got both details on it?
Well, not yet, in as much that we're here today and the licence hasn't been issued. But you're absolutely right. In the event that you embed the noise management policy within the premises licence, then that becomes a requirement, and breach of that is actually a criminal offence. So yes, there will be the duty manager's telephone in the window and made available. In fact, we'll put it through everybody's door in the vicinity if you wish. Save them phoning up Miss Walker, or if there were to be problems. Obviously, the first recourse is to get hold of the duty manager and say, what on earth's going down there? Get a grip of your people. You know, so we will widely disseminate that telephone number. So.
Thank you.
Thank you. Just to sort of explore a little bit the potential that for noise, which does seem to be the one of the major concerns. Will there be any preparation of food or desserts going on during these hours after 11 p.m? So is there going to be sort of kitchen noise, or is it purely going to be a case of handing food over to a person who will then do the delivering?
So when it comes to desserts, especially the ones which we'll be making, majority of the products do come as waffle mixes, sort of which we will obviously make during the early hours of our opening hours. But obviously the actual making of the product, like flipping over the waffle iron, you know, putting things into the microwave, the use of, you know, milkshake machines, obviously those itself, you know, for a machine to work, you know, it's a operating machine. It may obviously cause noise. We can't necessarily stop the noise to a certain extent. Hence why we were obviously trying to kind of create all these products beforehand. And majority of products is like cakes, waffles, things like that, which are already pre-made anyway. So there won't be necessarily lots of noise being produced throughout the night. It'll be, you know, cakes which you can get, you know, pre-made cakes. All it takes is a cake to actually, you know, put into a bag.
Okay, that's fine, thank you. Good. What I think, what I know he's explained is that the majority of prep happens at the beginning of the tour of duty. Not when he says the early hours, it doesn't mean the early hours of the night. It means the early hours of the duty. So if you open at 10 o'clock in the morning, it's going to be between 10 and 11. You can be prepping the stuff. Second thing is, the noise from the milkshake machine, that's not actually a licensable activity. Okay, it's the noise from the licensable activity, which is the production, which is the supply of the hot food and drink. So, the noise from the milkshake machine, that's not a licensable activity, but the noise from the waffle machine is. It's a bit of an interesting one. What they're particularly seeking clarification is, you know, when you have a pizza operation and there's pizza tins getting banged on tables and people, you know, chopping them up and whatever, is this going to be a noisy operation? If you can answer that question, please give them that.
I don't think it will be a noisy operation because we won't be banging cakes onto you know, the tables. We won't be banging products. It's literally could be pre-made products, which is already packed. It will literally be cake slices out of a window display being put into a box. We're not going to be getting metal tins, you know, baking stuff in the middle of the night, you know, grabbing eggs, flour, all this stuff. We won't be doing that. So I don't think it'll be a noisy operation.
Perfect. Thank you.
Thank you. And then just to ask about the, we're talking just about delivery drivers, aren't we? That after 11 there'll be no members of the public. So will they be coming in solely from the front of the premises? And will there be any activities at the rear of the premises?
Yes, you're talking about the delivery, the collection by the couriers. Okay, we're saying that the majority of that will be by bicycle. Okay, that's the first thing. Secondly, strangely enough, the couriers moving cold ice creams and milkshakes and whatever, that's not licensable, so they're excluded from that. But the couriers, the orders involving the supply of hot food and drink will be collected from the front. Yeah, there is no rear access to the premises for deliveries. Thank you.
And presumably there'll be no deliveries of ingredients or anything like that?
There will be no delivery of ingredients because that will all get delivered during the actual day itself. Our suppliers don't deliver in the middle of the night. They don't deliver 8 o'clock, 9 o'clock, you know, in the evening. That all gets done during the actual day where there's daylight hours, where, you know, because we've already had this conversation with our suppliers, and they don't do deliveries outside of their hours, and their hours obviously during the opening hours of the morning part, essentially.
If you want some reassurance about that, Councillor, we've got no problems to you setting delivery of ingredients, if you know what I mean. To stock delivery time parameters on that, because they simply don't deliver at night anyway. Okay, thank you.
And you've mentioned this distinction between licensable activity and other activity. And if the licence wasn't granted, would you be planning to continue to offer delivery services to items that aren't covered by licence?
Well, they're perfectly entitled to do that, sir. Yes.
One final question. Have you made any assumptions in your business plan about the likely number of deliveries per hour? I know it's sort of how long is a piece of string type question, but have you made any assumptions about how many deliveries per hour there might be during the licensable period?
I think referring back to what you said, it's like as long as how long is a piece of string, essentially. Yeah.
Yes, there are 4 members of staff there. Okay. We are not expecting queues of people down the street. This is a very specialised thing. This is not hot food. This is not hot chicken. These are not burgers. It's not fast food. This is very specialist, if you know what I mean. This is a dessert. There's only one other dessert shop in the city. I think that's called Heavenly Desserts, which you've already licensed until 2 a.m. How far is that, sorry, from the premises?
I think it's about a minute and a half walk away from where we are. 2 minutes at max.
Okay. I know, we're not here to discuss other premises licences, I know, but it's quite a rare thing as concerns the city compared with everything else you've got going on down the Cathedral Quarter and what have you. But that's the distinction we make. We are not expecting to be overrun by crowds of people wanting milkshakes and gâteau at 1 o'clock in the morning. Thank you. Well, in fact, no, that's not right, is it? Because they're not even going to be in there, okay, at those hours, right? We're not expected to be overrun by orders and streams of vans coming by because we're bicycle born, primarily, and secondly, it is what it is, a piece of string.
I've just got a couple of questions, if I may. So the 11 o'clock potential closing at 11 o'clock, when will the customers actually leave the premises? Have you got a policy in place for, because it's not like a pub where you've got a 20-minute window, have you got an actual policy of when they will actually be leaving?
And again, great question. If you look at 3.12, what we did is last orders 10 minutes beforehand. So 22.50, that sort of towels up, as it were, an old, and then no consumption of food and drink, and we'll be closed, shutters down at 2300 hours, ma'am.
So in terms of people on the premises, I presume there'll be seating. Is the seating or is it just a takeaway? That's the next. No, there's seating, isn't there? That's on the plan. So those people who are in there, who's bought something at 10 to 11, can they then go and sit down and consume it, or would you be saying you'd have to take it out, or would you allow a certain time for those to finish their food?
No, customers won't be allowed shutters down essentially before, so we won't obviously allow customers to order for them to eat in. It will literally be when it's before 11 even, we'll already inform customers to, we close before 11, no customers on site. Thank you.
So maybe, say a 22:45 entry, last entry or something might suffice for that. The other thing is, forgive me if I've missed it, the refuse collections, presumably they will be around the back of the premises, and do you have a policy for when you will be, obviously clanging and banging of bins is an added noise?
So obviously, when you talk about refuse collection is done by external companies. They don't do
Sorry, I wasn't talking about collection. I was talking about you physically putting waste in bins and clanging the bins.
Yeah. So that won't be done past the hours of 11 anyways. That gets done in the morning. So obviously you can put the bin bags away inside the shop, and then in the morning when we come onto shop, they can be placed inside the actual collection, the waste sort of area.
And are the refuse bins around the back of the premises?
So the actual premises itself, right next to the shop, there's a waste collection hold. So that's at the front of the premises, and that's where all the waste goes.
Yeah, I just want to clarify one of the sort of crux of the arguments there is that they've got a lease that allows them to open late anyway. How that leases came about and being so different from all the other leases, yeah, I'm aware of that, but Anne was very clear that that was not to be raised as part of this. This is about have we met the licensing conditions, and that consideration wasn't to be taken into account. So I just want to clarify that that is the case. And then secondly, he talks about evidence. So evidence, they're saying they don't think it's going to be noisy. They don't know. We don't have any details as we stand here today as to what soundproofing we've got downstairs, what type of machinery will be working. And if we look outside, talk about fear, well, drivers coming from companies that you've no control over, parking outside, car engines coming on and off, doors closing, that's not fear, that's just a fact. The other aspect in terms of the noise management plan is it didn't have any real detail in it, it hasn't even been signed. So in terms of evidence, it's not been presented at all. Yeah, just to clarify, the bins are at the front of the premises. The original licence application, as they have wished, says that after closing hours, they will access those bins to basically get rid of any waste food. Those bin locations, that refuge is directly below the windows on the street. There is no back entrance. Everything has to go through the front of the street. And like I say, every property on that street has got 2 bedrooms facing over and extremely large windows, and we need to have air vents and windows open to make that habitable. So the noise disturbance that will meet the definition of a statutory nuisance will occur, and that will occur from vehicles. That's not fear, that's just a fact.
Thank you. Do you have any response to any of those questions? No, we won't. We'll put the microphone on. We'll move to summing up then in the order that you spoke, if that's okay. So, Anne from the Licensing Authority first, please.
Thank you. I've not a lot to add, Chair. Just to remind committee that you can grant the application, modify the conditions of the licence, or reject the whole or part of the application.
Thank you, Anne. Mr. Gillespie, do you want to sum up?
Yeah, well, I think I've just covered most of it there, but yeah, fundamentally this is going to increase the noise in this area significantly, and an area that doesn't have any through traffic or any late night noise, and we're going to have delivery vehicles, again, that they don't have any control over. There isn't a noise management plan for that, and there isn't any evidence of how the noise from the property that will be operating into the late hours, how that will be restricted into a level that's acceptable for the residents, both above the property and in the street.
Thank you. Would you like to do any summing up? Okay. So, Mr. Semper, summing up, please.
Yeah, I was following your lead there. Yeah, so this, you know, yeah, it's the thing is you get focused on the paper, you forget the, you're used to it because obviously this is your other home. Now look, a lot of this is about the permitted uses of this premises, okay? I've been through the planning, there are no restrictions and the lease allows this, okay? Planning is a consideration, sir, for the licensing committee because they're statutory consultees in the process of the grant of a licensing of a license by the licensing authority. So, and I've explained that planning and business uses lies outside this remit, but it's the remit of those of you that sit on the planning authority as well. Okay. So the next thing I'd point out is that the gentleman, Mr. Gillespie, he's 3 times in his summary on questions and whatnot, he's mentioned fear. the case I referred to, there's two sides of that coin. There's fear on the one side. I'm not saying he's scared of anything or anyone. It's actually the speculative nature of what he suspects will happen. Fear and speculation, as I've explained, and the lawyer will deal with it in recess and give them legal advice, I'm sure. With respect, your objections are based on speculation that there will be problems, and I'm saying there won't be, but were there to be, these good people have the power to close the place, to review the licence, to stop it, to remedy whatever were to go wrong, if it were to go wrong. Okay. Chair and panel, we've already offered the noise management plan. The fact that it's not signed, it doesn't need to be signed until you embed it. And I offer you the facility to do. I suggest, in fact, it's not for me to offer anything to you. I suggest that if you were to embed it as a licensing condition, and it will be signed, will become part of that license. Okay. Secondly, we've got no problems about putting out bins late at night, or about not putting out bins late at night, if you wish to condition that, which you rightly said, you know, what time. So no bins out after 8 o'clock at night or 7 o'clock, whatever you want, whatever the norm is for Derby City Council. The concern that there is no control by these gentlemen, this business, over third-party couriers is simply not right, because it's very contractual. We represent an awful lot of online online alcohol shops, wine shops, gin distilleries, third-party pick, pack and dispatch operations up and down the country, and it is highly contractual. And if your delivery drivers are bringing your company into disrepute by their wanton disregard of your neighbours, boom, that's it. Okay, so there is plenty of control around delivery drivers, even if they are third party. So in summary, ma'am, what I'd say is this hearing is simply about whether this new dessert cafe, selling no alcohol but only cold desserts, milkshakes and occasional hot drinks, waffles and cookie dough, closed to the public after 2,300 hours, and let's be clear, he says, shutters down 2,300 hours to members of the public, everybody off. Operating this revised licence hours in accordance with the operating schedule before you, and including a comprehensive raft of conditions agreed with the police, combined with the comprehensive noise management plan. The question is, will it undermine the licensing objectives, or will it promote them? Very clearly, our position is it will not undermine them. They've got no intention of being bad neighbours, and the offers before you guarantee that. This application is as inoffensive as it is insignificant in licensing terms. It's a de minimis. It's probably the tiniest sort of license that's probably you've ever sat on the desk before you, okay, in licensing terms. And can I remind you that all the responsible authorities, the licensing experts in Derbyshire and Derby City, raised no issues whatsoever with its substance, content, or the additional inbuilt safeguards. There is no recorded history or indelible evidence of noise nuisance, pollution, safety, ASB, drugs, underage sale, crime disorder, or even burglaries with the operation of these premises, or indeed any other cause for concern if evidenced involving this application or these applicants or any other outlet or any of their outlets they've been associated with before you. That is quite simply an undeniable and self-evident fact, and therefore, consequently, I respectfully request that you do indeed grant this tiny application for this premises licence as sought, supported by that comprehensive raft of effective conditions and any others that you, panel, deem appropriate and proportionate, and that in fact you wish Shoaib and Adam every ongoing success with this new venture. Thank you very much indeed. Thank you.
Thank you very much. So we will now retire and make our decision. If you check with Jackie, I think she's got everybody's email addresses. Yeah. Oh, sorry, check with Anne. Sorry, I wondered what you were doing that for. Check with Anne, not Jackie. You've got all the email addresses correct, and then so it'll either be later today or tomorrow morning, if that's okay. Thank you very much for attending.